Hey everybody, I'm Chris, and I'm here to tell you a little bit about life insurance in the context of estate planning. So some interesting things about life insurance in North Carolina is that we actually have built into our state constitution a provision which helps protect life insurance after you die. What I mean by that is if you have a life insurance policy where your spouse or your children are to benefit from it when you die, the Constitution of North Carolina says that creditors can't attach to that. So if you, in your later years, accumulate a bunch of debt, either through your own action or through things you can't control, right? Like being in a nursing home for several years and accumulating lots of debt. After you die, it may be that your entire estate gets wiped out, paying off your creditors and paying for the costs and dealing with taxes. But life insurance is an exception under our state constitution. That life insurance, if it's going to benefit the spouse or the children or both of the deceased person, is protected from creditors, meaning that even if all of your estate gets wiped out due to things that happen to you, and your family would otherwise be destitute or would have nothing to benefit from as a result of your death, this life insurance policy that you keep and maintain, if you're able to keep those premiums paid and you die during that policy period, that could provide a substantial inheritance for your relatives, an inheritance they might not otherwise receive. The other thing that's really interesting about life insurance is it really matters who you name as beneficiary. Your spouse being your beneficiary is very common. Also, what's very common is people name their children as their backup beneficiaries, or if they're not married but they have children, they'll often name their children as their beneficiary. And what's so interesting about that in North Carolina is if you have a beneficiary that is a child, and by child, I don't just mean your child. I mean a child who's still a minor, still under the age of 18. Some insurance plans, some life insurance plans do account for that, but most don't. Most say that someone that's left behind with the child needs to go apply to the court to become appointed as the person that's designated to manage this money for the child. And so if you name a child that's a minor directly as a beneficiary on life insurance, you might think you're helping things. You might think you're doing something good, and you might be. But there's also a downside to that. If that person's still a minor when they're determined to be your beneficiary of your life insurance, and someone else has to go to court to be appointed to manage that for them, it might be a family member, it might be someone you've never met. But when someone gets appointed, they have to take that child's money, and they have to use some of it to go buy an insurance policy that insures against the risk that the person that the court appointed runs off and steals the money. And so the insurance company gets paid a premium from your child's money, and that insurance company will then tell the court, well, yeah, if this person runs off, we will pay the premium, or we will pay what's stolen, and then we'll go after the person and try to recover that on our own. So it's important, right? It provides some security for the money and for the people that are being appointed, that if something does go wrong, there's a source of funds that will help replenish that stockpile of stolen funds. But it's very expensive. And if there's people that you trust that you want to name to be in charge of this money in advance, there's better ways to do it. There are ways to do it where you don't have to pay for those expensive insurance policies. They're called surety bonds. And there's ways to do it where you don't have this continual court oversight. Because after they spend your child's money to get this insurance policy, the next thing they do is they have to file stuff with the court, showing an inventory of all the assets that are under their control, how much money they have and where they have it. And they have to have supporting documentation. And then every year, they have to go back to court. The people that get appointed, they have to go back to court with, a stack of paperwork sometimes with all of their itemizations of everything that they've received and everything they've spent. They have to have proof, right? If there was a bill that was paid, they have to have the bill, and they have to have proof of payment of the bill, right? We don't want any question about where that money was spent. And so the court will very meticulously audit that, and they'll go back and forth with the guardian. That's what they call this role. They'll go back and forth with the person until they're satisfied. And that can be a pretty difficult process, and it can be difficult to do this paperwork correctly in a way that passes these audits. And so sometimes people will get professional help to do it. We routinely here get hired to do that all the time. But then that costs money, right? Like professional services cost money. And so that will deplete or lessen the amount that the beneficiary is ultimately going to receive. And then the part that concerns me the most, outside of the cost and the headache for the people you're leaving behind, is at 18, they give all the money to the child. They don't really ask if the child is still too young or too immature. They don't really evaluate that. And that's probably because the child has rights, right? When they're an adult, they're an adult. But that's not always a good decision. There are 18-year-olds that are really responsible with money, but a lot aren't. And more importantly, you're talking about an 18-year-old who might have dead parents, who might have gone through some stuff, who might have had a very severely disrupted lifestyle, at a young age or in their teenage years, in their formative years, and they might not be ready to receive mom and dad's large inheritance, right? At 18, they might do something dangerous with it, or they might do something wasteful with it at best. And so a lot of times people who are naming their children as beneficiary, they don't understand that that's the system that we have, right? We have this fairly bureaucratic system that's meant to protect the child and protect the money and that sort of stuff. But there's definitely some downsides to it, including privacy. Even though these files involve children, you can go to a courthouse and pull these children's files, and you can learn all kinds of things about the child. You can learn all kinds of things about the assets that they have. You can learn when they're turning 18. There's lots of stuff you can glean from these records. It's really concerning about privacy. And in North Carolina specifically, we're migrating to electronic court systems, so electronic filings and electronic record keeping. So even though we're a little behind the times on that, eventually what's going to happen is we're going to be able to pull up these files all over the state by just searching for people's names and being able to access financial records like that. Like, they don't seal these records. Some stuff is probably going to be kept private on the electronic system, but you can walk into a courthouse and get a lot of information. So those kinds of privacy concerns with the money and the expense and the aggravation to the people that are left behind having to deal with the court system, and then ultimately the fact that they're getting the money at such a young age without any real qualifications, those are a lot of concerns that make people not want to name a beneficiary directly that's a minor child. And so what do people do? Well, in my case, and a lot of people's cases, they create something to receive that money. In my case, and what I recommend for a lot of clients is, if you have minor children, a trust is a good tool. There's different kinds of trusts out there, and depending on your situation, one trust might be better than another, but generally, a trust is a good mechanism because you can create an entity, essentially called a trust. You can create these rules about what it can and can't be spent on, right? Just like you would as a parent. Like, if you have money for your child, you can direct how it's going to be spent. Well, a trust allows you to do that after you die. And so if you point a life insurance policy to be received by a trust at death, you go to that life insurance policy paperwork, you name this trust that you've created as the beneficiary. You die, the person that's in charge of that trust when you die, which is named in the trust documents, goes to the life insurance company, fills out their claim paperwork, they get the death benefit paid to the trust. Then all the rules that you put in this trust agreement apply to the property that's in the name of the trust, which would include the death benefits from the life insurance. And so if you have minor children and you want to name a beneficiary in a way where they can benefit from it, but you don't want the aggravation of sort of the default rules and the default way of doing things that the rest of us have to deal with that don't do adequate planning, what you can do is you can do some planning. You can create a trust that will act as this intervening step. And the benefits of that basically are more privacy, right? Generally speaking, unless there's lawsuits or something, these trusts are generally much more private. They're much more efficiently run, meaning you're not waiting on audits and things. You can just get things done very quickly, relatively speaking. There's a lot more control over how the money is spent. It's not subject to, the whims of the court system and the people who are employed by it. In general, it allows some flexibility. You can really, really get into the weeds on how this money is spent or what it's spent on, what things are important to you, what things you want to prioritize. So, if someone else is having to manage this money for your children because you died, you can pretty much call the shots from the grave to a great degree and for a very long time if you want. Now, not everybody does that. Sometimes people will say, well, until they're 25 or until they're 30 or until there's some age that's older than 18, perhaps, this money can be managed for their benefit. It could be used for things that they need, perhaps things that they want, but it would be at the discretion of someone that's more responsible than an 18-year-old, right? It would be at the discretion of someone who's older, who's more mature, who you've already gotten to see in action and how they live their life, and you can entrust them with that responsibility, at least trust them more than you would trust an 18-year-old with their dead parents' inheritance. Interesting things about life insurance. It's a great tool for getting money directly to named beneficiaries. You have to be careful with minors, though. It's a great tool for providing an inheritance for people when there is a concern about creditors. Because there's an exception. And generally, it's a great tool to add to your arsenal of estate planning tools to ensure that your family has some sort of inheritance. And if you die untimely, that there's a replacement income, replacement assets that will be able to fund the things that you would have been able to fund had you been living and continuing to earn income and make a living. Now, I hope this has been helpful. If you have more questions, feel free to reach out, and thank you for joining us.